So let us continue, that is from the last class. So I was speaking about the essentials of valid contract. So 7th point is about legality of the object. So purpose for which the agreement has been entered into by the parties, it must be lawful or legal. If the object or purpose of the agreement is unlawful, then the agreement will be void and then it cannot be enforceable by law. Object of an agreement will be lawful unless when it is forbidden by law, when it is of such a nature that it would defeat the provisions of any law, or if it is of fraudulent or causes any injury to the person or person's property, or immoral, or it is opposed to public policy. Here the consideration and the object which goes hand in hand, okay, because both the essentials should be legal, lawful one. And the 8th one is certainty. What is the certainty? The agreement must be certain. That is, the term of the agreement must be certain or at least capable of being made certain. Suppose A agrees to sell B, that is 100 tons of oil. There is nothing in the agreement about the kind of oil which is intended. In this case, it is not clear that as to what kind of oil is intended to be sold. That is, agreement is vague or uncertain and so it is void. And the 9th point is possibility of performance. Agreement must be capable of being performed. That is, the terms of the agreement must be capable of the performance. So section 56 of the Indian Contract Act lays down that an agreement to do an act impossible is itself void. If A agrees with B to discover treasure by magic, then the agreement is void as it cannot be performed physically. 10th one is about not expressly declared to be void. To be enforceable by law, the agreement must not have been expressly declared to be void under the Indian Contract Act or under any other act in force that is in the country. If an agreement has been expressly declared to be void under the Indian Contract Act or any other law in force which is in the country, it cannot be enforced at law. So section 24 to 30 of the Indian Contract Act specify certain types of agreements which have been expressly declared to be void. So some of these agreements are an agreement in restraint of marriage, an agreement in restraint of trade, an agreement in restraint of legal proceedings, and wagering agreement. And the last one is legal formalities as to writing and registration. So as per section 9 of the Indian Contract Act 1872, an agreement may be in oral or writing. The agreements are required to be in writing and registered by law. The legal formalities as to writing and registration has to be complied with if the agreements are to be enforced. If the legal formalities as to writing and registration are not complied with, then the agreements are not enforceable by law. So that is to conclude, for the enforceability of an agreement at law, each of the various essentials or elements of a valid contract enumerated above must be present. If any one is absent, the agreement doesn't become a contract. So here it says that contract and agreement. One of the authors says that agreement is only an agreement. Contract is an agreement. So there is a difference between an agreement as well as a contract. So agreement cannot be a contract, but contract can be an agreement. Okay. So it says that here agreement is equal to offer and acceptance and the contract is equal to agreement plus enforceability. So to conclude with, contract is an agreement between the two parties which is enforceable by law. So we take up in the continue in the next class. Thank you.